I have not had this many sanctions given to one person, as many chances as she's been given. She's been given more than almost anyone else I've ever seen.
I'm sorry. I asked her.
Don't argue with me.
Okay,
I listened to what you had to say, so why don't you listen to me now? This is one of those cases, Ms. Campbell Roundtree, that I believe the court needs to save you from yourself. Don't take this wrong. You're a mess. And the only way that we can save you from yourself is to impose a long-term period of incarceration.
Please don't put me in prison. I need to work. I need to take care of my family. I can prove to you I can do this. Sir, I can't. I can prove it. I promise I can prove it. I know people say that all the time.
Shannon Campbell Roundtree?
Yes.
You were set to appear before this court.
We got the road construction on the way here. We came from Chanute.
This isn't your usual courtroom back and forth. This is a live demonstration of what happens when someone treats the legal system like it's optional. She walks in with that none of this applies to me energy, and within minutes, you can see the judge deciding he's done playing nice. Every answer she gives drips with deflection, like she's allergic to accountability, and it's written all over her body language. By the time the judge pushes back, the whole exchange is teetering between comedy and disaster. Is this just peak entitlement or something else entirely? Let's go ahead and dive in.
We got here about 10 after. I'm sorry.
Okay, I heard Chanute, and I'm sorry, and I didn't understand much else.
There was
a
construction
delay.
Which, of course, you should have allowed for by planning to get to Eureka much earlier so that you're not late and holding up
correct, sir.
a number of professionals who are waiting on you to take up your case. This is State versus Shannon L. Campbell Roundtree. Shannon Campbell Roundtree has now joined us. Earlier, the court, due to her non-appearance, entered an order of bond forfeiture, bench warrant, and a no bond hold due to her failure to appear. This time, the court is going to set aside that order because we are going to address the warrant to show cause matter today. With that now announced, Mr. Paul, what are your client's intentions?
Judge, my client's intentions are to admit to the 3 violations as outlined in the amended motion to revoke probation that was filed August 8th of 2024 and proceed to disposition at this time before we go over evidentiary hearing.
Ms. Campbell Roundtree, I'm going to read the alleged violations that are in the motion to revoke probation as amended. Defendant failed and was instructed by her ISO to report to the Greenwood County Jail on May 24, 2024 to serve a 48-hour jail sanction due to admitted to having consumed methamphetamine on May 7th, 2024. The defendant failed to report to the jail as instructed. Number 2, the defendant failed to abide by the rules of the 31st District Drug Court as directed. Number 3, defendant submitted a urine sample on August 7th, 2024 that tested positive for amphetamine/methamphetamine. The defendant signed a statement of admittance to this usage. Among other lesser remedies, the court could consider just revoking your probation outright and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, sir. Could I say why I didn't show up for that weekend?
First, I need you to tell me if you are waiving a hearing and are admitting these violations.
Yeah, I'm waiving my hearing.
The court does find that the defendant has knowingly waived her right to a hearing in this case and has stipulated and agreed that she committed the violations as alleged and read off by the court earlier. These are substantial and material violations of the terms and conditions of Shannon Campbell Roundtree's probation. The court will now turn to a dispositional phase. I'll ask for recommendations. I'm going to start off with Mr. Ketley again. Mr. Ketley, how do you see this case?
Her case has been kind of a long drawn out case, Your Honor, when we've had issues through the drug court and stuff down there. I will note that I had a UA last week and she was positive for amphetamines, which she admitted to.
Ms. Gillette, your recommendations regarding an appropriate disposition.
I say this frequently in all the different courts. Choices have consequences. My own choices have consequences. All of us that work in the judicial system understand this. I am aware of the 31st Judicial District's drug court program. I'm very aware of how hard they work to help people stay on the straight and narrow. But Miss Campbell Roundtree did not take advantage of the drug courts programs and all the things that are offered. I have not had this many sanctions given to one person to try to help her. It is astounding to me the number that she's had. And I have all of
How
them
many
here.
is that? How many is that, Ms. Gillette?
1, 2, 3, 4. There's 4 sanctions here. She was to have a 3-day weekend on 10/8.
Racking up 4 sanctions isn't just bad, it's the legal equivalent of speedrunning your way to the worst possible outcome. Each one is a formal record of the court saying you've crossed the line, and stacking them sends a crystal clear message that you're out of chances. At this stage, the judge isn't trying to correct her behavior anymore. They're documenting every misstep to justify whatever hammer they drop next. It's like watching someone build their own prison cell all in real time.
And a 3-day sanction on 10/15 as well. Both of these are for having positives in failing to refrain from using substances. So she's been given 4 sanctions in this case without having to come here and stand for formal revocation in front of the court. She's been given opportunity after opportunity after opportunity. And I also know that there was a drug bust in Neosho County that Miss Roundtree was at. She's been given extraordinary chances to follow through. I just don't think that she is amenable to treatment. When she was ordered to do this last sanction, you got to be there to do your sanction and you got to show up. As many chances as she's been given more than almost anyone else I've ever seen. And she has not availed herself of those chances.
Sir, can I see why I wasn't available for that?
I'll give you an opportunity to address the court later. Mr. Pa, on behalf of your client, what are your recommendations regarding an appropriate disposition?
Judge, this is her, I would say, first formal probation violation in front of you, Your Honor. The first time that she's had counsel, she has waived it in the past. She's had her same job for many years now. As it is very apparent, Miss Campbell Roundtree has a substance abuse issue, and it's probably a little more serious than she thinks it is. I would ask that you sanction her appropriately and reinstate her probation at this time.
Campbell Roundtree, you wish to address the court and make a statement at this time in mitigation of punishment?
Sorry, yes. I've always abided by my sanctions, and I go to my outpatient groups. I always get men by everything. When I was supposed to do the sanction that weekend, I had been addressing in class and with my ISO that my daughter started having a drug problem, and that was really weighing on me really hard. And that same Friday, she was having delusions and whatever. An ambulance was called for her, and so an ambulance came, and they came and found her out, not knowing what was going on. They got the police. The police had they got a search warrant for the house. So I was at work at the time. She was at the hospital. They searched the house, and basically everything was found in her room except for some paraphernalia. I've been addressing this for about a month or so at my outpatient group and with my ASO that how concerned I was about this. So that Friday, they searched the house. They arrested all of us, my husband, me, and my daughter, and we all had to stay in the Neosho County jail. That's why I didn't make my sanction. Otherwise, I have complied with everything. I've paid everything off.
Let me back up a minute. So you didn't report for your sanction because you had been taken into custody? She'd been arrested?
Yeah, with the whole family. The whole family was. Because we all
did you bond out then? Did you bond out?
Yeah, several days later. was like 7 days later.
Did you then report to the jail as soon as you bonded out?
Yes, I did.
Did she voluntarily surrender herself after she was released from custody over apparently after this drug bust?
Court. We got the warrant over to drug court and they arrested her when she showed up into drug court.
But I reported my ISO immediately after I got out. I had a friend call her my ISO from until I was in there. I didn't know they knew that. And I tried to call her when they were arresting me, but they said I only had, phone.
Campbell Roundtree, hang on a second. I'm just trying to understand the whole sequence of events here.
Okay.
So you got arrested and you're saying you couldn't show up for the sanction that Mr. Ketley had it essentially imposed upon you because you'd been arrested. And then you got released on bond, but you didn't go to the jail. You went to go see your ISO on the 31st instead. Is that what you're telling me?
Correct. I called her and said, hey, I just got out of jail. What do you mean do? She said, go to drug court tomorrow. It's like late at night. Go to drug court. And then they arrested me at drug court because I didn't know what was going on. I had no idea. I went to drug court.
Did you think that we were just going to let it go when you were supposed to?
No, sir, I did not. I didn't know what to do. I was asking my ISO what to do. I reported to her.
Did she even know that you had a sanction that you were to report to the jail for?
Right, but I was letting her know. I let her know that's where I was. That's why I wasn't there. And she said, okay, you have drug court tomorrow because it's late at night. Report to drug court tomorrow. I said,
nobody in that courtroom looks convinced. Her delivery is so casual it borders on taunting. The details don't connect, the pacing feels rehearsed, and every answer just adds another crack to whatever credibility she had left. The prosecutor isn't even poking for weak spots anymore, she's systematically dismantling the whole thing like it's a foregone conclusion. At this point, it's less about whether the story holds up and more about how fast it collapses.
Okay, she said, come to me first. At the time, I was wearing the drug patch that you wear instead of taking UAs, you wear a patch and they check that, which is clean. I can prove it was clean. That's what my ASO Jackie told me to do at the time.
What do you think this court should do due to your non-compliance?
I know I owe a sanction. I do know I owe that, but I've been complying with everything. I'm trying really hard. I work, I take care of my family, I do all that. And I've been struggling with this problem with my daughter now for like months about this because of the struggle. And then that happened. So, but I informed Jacqueline of all of this. I had a friend call her while we were in jail in Neosho about being in jail and about my sanction. So she could let somebody know that I wasn't just blowing it off because I was not. I'm sorry. I mean, I've been doing my best. I worked the same job for 11 years. I'm working my best to do this. And I just want to comply with everything. I understand I have to be accountable for my actions.
All right, Ms. Campbell Roundtree, your crime of conviction was possession of methamphetamine. Almost always, that connotes that the person who's in possession of the drug is a user of that drug.
Right.
So on these level 5 possession of methamphetamine cases, treatment is the focus.
Right.
Much more than punishment.
Right.
What all we expect in return is that the person who's been given the opportunity on probation for a rehabilitative purpose to take that seriously, embrace the treatment alternative to prison, and rather be successful in the community while addressing a drug problem.
Yes, sir.
You haven't been that. The number of sanctions, which I think Ms. Gillette reviewed for this court, indicates that the officer has tried and tried and tried to work with you, but each time you commit some sort of serious violation of the terms and conditions of your probation, and rather to seek revocation, he's tried to work with you in trying to get your attention through quick dip sanctions, which apparently you've had 4 of them. I'm still disturbed about the last one when he again tried to work with you. You were to report to the jail for a sanction and you went and got yourself arrested so that you weren't available to report for that sanction. It would seem to me that you should have known that the first thing you needed to do after you made bond was perhaps inform your ISO what was going on, but then report to the Greenwood County Jail yourself, surrender yourself the way you were supposed to originally.
I'm sorry. I
Okay,
asked her.
don't argue with me.
Okay,
I listened to what you had to say, so why don't you listen to me now?
Okay.
I'm inclined to agree with Ms. Gillette. This is one of those cases, Ms. Campbell-Roundtree, that I believe the court needs to save you from yourself, because you don't seem to be able to make the good decisions necessary to be successful in a treatment program, which is meant to modify your behavior and to help you make better judgments. You were sentenced in this case on October the 5th of 2022. Here we are deep into 2024, and it doesn't even look like to the court that you've made any real progress in all this time, despite everything that Mr. Ketley has tried to work with you on and that treatment has tried to address. I think, using a colloquial term, don't take this wrong, you're a mess. And the only way that we can save you from yourself is to impose a long-term period of incarceration where maybe you have the opportunity to be separated from these ugly drugs for so long that you won't want them anymore. And in a drug possession case, the court considers this a last resort, but I see no reason to waste any more resources. You know, I can't return you to the drug court program because I have an order from Chief Judge Kreitz which terminates you unsuccessfully from that program. So we tried to work with you in a drug court situation. You failed that. They've kicked you out, essentially. And I'm not going to waste any more resources for someone who's not likely to be successful in the utilization of those resources. So the court will exercise its discretion under KSA 223716.
The judge isn't circling jail time because he's eager to punish, he's circling it because every softer option has been chewed up and spit out. When someone burns through diversion programs, probation terms, and court-ordered help, the system eventually shifts from let's rehabilitate to let's contain. That's not cruelty, that's risk management. Protecting the defendant from themselves and the public from the fallout. And the way this hearing is going, it's clear the court sees more danger in letting her walk than locking her up.
I will make a finding in this case that Ms. Campbell-Roundtree has been willfully non-compliant with any treatment alternative that was intended in this case, that she's not amenable to probation, and it's not in her best interest to remain in the community where she's constantly exposed to and uses illegal drugs. So the court will enter an order outright revoking her probation, ordering her to serve time in Department of Corrections custody, starting with today. The court further will modify the sentence from its original 15 months to 1 year, 12 months, less any jail time or good time credits, which are to be properly computed. I don't know if you have a handle on that number right now, Ms. Gillette, total jail time credit days.
Yes, 7 days for the 7 days of sanctions she did.
And that's it?
She had no original term. She didn't spend any time in.
She will be awarded the 7 days jail time credit to be placed in the journal entry, which stems from today. No further fees will be assessed for bids amounts, given the court's incarceration order.
Please, can you just a few minutes of it? I've got to take care of my family.
Okay, settle down a little bit. If you're addressing the court, I want to be able to understand you, okay? Now, Ms. Campbell-Roundtree, I've already entered an order revoking your probation outright, shortening your sentence to 12 months in duration, though you've done very little to earn that reduced sentence, but I believe a year will be enough. So what are you trying to tell me here?
I know I had a problem. I've been an addict. I've been trying to help my daughter. Please don't put me in prison. I need to work. I need to take care of my family. I can prove to you I can do this. I can
Okay,
do it. The only
Ms.
reason
Campbell
I can
Roundtree, let
do
me interrupt
everything.
you and just say, if you really cared about your job and your family, you would
Yeah.
have taken steps along the way to be more successful on this felony probation, and you didn't. So you're not willing to conform your behavior ultimately to be
Sir, I
successful.
can't. I can prove it. I promise I can prove it. I know people say that all the time, but I can prove it. I got a husband on disability. I've got a daughter that's having a problem right now.
Okay, we're not going to argue all afternoon about this. The court has made its ruling. I would have rather you been successful in the drug court program and sat before this court as a success rather than as a failure.
Okay.
You had that opportunity through 31st Judicial District Drug Court, and you blew it. So the court's ordering prison in this case for the remainder of a 12-month sentence. I'm going to order her to be taken into custody at the conclusion of this hearing by the representatives of the Greenwood County Sheriff's Department until her custody can be transferred to the Secretary of Corrections.
All right.
Anything else, counsel, that we need to address? Oh, I need to address post-release supervision period, which I presume 12 months. Yes, 12 months post-release supervision period is re-announced. Ms. Gillette, do you need any further clarification from the court?
I don't believe so, Your Honor.
Mr. Pod, do you?
No, Your Honor.
Very well. Then again, I'm ordering her into immediate custody to be placed in jail and on a hold until she can be transported to the Secretary of Corrections facility. Take advantage of whatever opportunities you have within the facility to get yourself straightened out, have to come back to court again on something like this. If there's nothing further, then the Shannon Campbell Roundtree matter will currently be in recess.
12 months in custody might not feel like a heavy hit, but in cases like this, it's less about the number and more about the message. When someone keeps pushing the limits of the court's patience, eventually the system shifts from help mode to containment mode. And that's exactly what happened here. The ripple effect isn't just on her life, it's on every other case that gets delayed, every docket that runs long, and every resource pulled away from people ready to actually change. That's why judges sometimes hand out what looks like a soft sentence because the real goal is to break the cycle, not just pad the calendar with more jail time. Do you think this was a calculated move to save her from herself, or just the court cutting its losses? Let me know below. Thank you guys so much for watching, and I'll catch you in the next one.